Hello, my name is Jay Chauhan. I manage the mentorship group in the Facebook called Angel Mentorship Group. This group is both on the Facebook as well as in our office, and there are 120 members now in the Angel Mentorship Group, and it's growing. If you are a lawyer or a paralegal or even a citizen interested in legal issues, please join, and we'll accept you because we want to support the administration of justice and the legal knowledge in the community and within the legal community as well. So today's topic that I want to cover, 7th of June 2018, is the question of what is negligence and what is professional misconduct of a lawyer or a paralegal, and to what extent these two concepts overlap with each other. So firstly, let me define the question of the negligence, and the way to understand negligence is to go back into the history of tort law, where the concept of negligence was developed in the English law. So the basic criteria of defining the negligence is a tort that each person or institution has, or a corporate body has, a duty of care to other people it deals with. And if you cross the threshold and you are negligent, you become liable in the law of negligence and tort for your responsibility to the person you owe the duty of care to. So the whole body of law has been developed around what is an appropriate duty of care in different areas of our activities. Let's take a couple of examples. The whole body of the law with respect to car accidents evolved out of the negligence law, and that was modified by the criteria of issues which are personal injury issues which go to court, and those that are administered through the insurance arrangement. But this is just an example how the law evolves. But in terms of another example is a surgeon or a lawyer. A lawyer or a surgeon or a professional person owes a duty of care to the client or a patient or a customer, as the case may be. So the thresholds of the duty and the skill required to be exercised are the duty and the standards of a particular given moment in time in history, where we're evolving the knowledge and the complexity of society, and the criteria is the standard of your profession in that arena of your activity. If you're a specialist in surgery, you have the standard of care of surgery in, let's say, knee surgery or a hip surgery. If you're a lawyer and you're a specialist in the trademark law, there are basics that you have to observe in terms of the knowledge, skill, and ability to help the client with that knowledge. But as you'll see, that a lot of the negligence cases arise out of the mechanical issues that are easily identifiable as issues of negligence. For example, missing the time limit. You're supposed to know, if you're a lawyer and want to carry out a case, there are time limits that you miss out, and that becomes negligence. So I won't go into more detail in terms of the different areas of negligence, but it would suffice to say for the short video that the negligence is arising out of the duty of care and out of the history of the tort law. Now let me address the question of the professional conduct and misconduct. How do you define the misconduct, and what is the overlapping arena of these two concepts? The professional misconduct is when a lawyer or a paralegal falls below the standard of the rules of professional conduct. These rules of professional conduct were also originally defined and arose out of the role of the barrister in the English society in the common law. And subsequently, and this goes back to about 13th century, 14th century, when the Inns of Court were developed, where the lawyers acted as barristers, and then they formed the societies. There were 4 Inns of Court in England, and when the law was brought in Canada with the the British North America Act in 1867, it became a part of the practice of Ontario, which was a separate colony at one time until the Confederation. And the Law Society Act, which is an act of the Ontario Parliament, then governs and delegates the responsibility to the Law Society. The Law Society then carries forward and amends the rules of professional conduct from time to time. So when a lawyer acting out of the rules of professional conduct falls below the standard required by the rules of professional conduct, then the Law Society can assume the responsibility of finding the misconduct with the criteria set out as the conduct required of a lawyer. And if you look at most of the rules of practice, how they've evolved, they're centered around the common law principles that you'll be acting for a client in his own interest. You will be then dealing with the opposing counsel and the court system with respect, courtesy, and dignity, because our mandate is primarily the mandate to resolve the issues of conflict in the society between individuals and institutions with appropriate conduct that is aimed at resolving the issue. Our duty, from my point of view, is not to over-assert or under-assert the cause of the client. So there was a recent case which just come out of Law Society of Upper Canada against Groia, Groia, which will be of interest to many of the listeners. So I hope you will read the case, and we will hopefully do another short video on the issue. So in this case, the issue of how assertive can you be as a lawyer, and how far is your duty to be assertive. So my opinion is that our duty to be assertive or over-assertive created the principle of the civility in the profession, and the rules of civility, in my view, are paramount, because the idea is not that you get to assert your client's cause at any cost to the other party, but rather in a just manner find a resolution of the problem by dealing with the opposing counsel in a reasonable manner. So I think that our duty first is to the client. Our duty, in my view, is also finding a resolution of the problem, because the whole common law system and the lawyer's knowledge, like a doctor, was designed for the benefit of society. But I think that by over-asserting the cause of the client, you're really helping to some degree yourself and saying, well, I make more fees, I have better reputation, but this desire to help yourself has to be tempered against the desire and the need for the lawyer to find a resolution of the problem. So I think that there are many cases that arise regularly in professional misconduct, and I hope this video was helpful, because it came up in the discussion today with my staff in my office, and this was an appropriate topic for our angel mentorship group. Hopefully we'll do a CPD program on it. I did one CPD program for this purpose on the professional rules of conduct last year, which was recognized by the Law Society as an education program. So we will be doing, in the rest of this year, 2018, a number of programs with paralegals and lawyers, because I think there is some hesitation on the part of the lawyers to accept the paralegals as a part of the profession. But I strongly believe that in the interest of trying to carry out our mandate to help the society, we have to include the paralegals in our profession and work with them to achieve the resolution of the conflicts in the society. And it is our mandate, and therefore I think that we should now accommodate the paralegals in every arena of our activity. So especially when they come in the small claims court, when I was a deputy judge, I made sure that I addressed them as counsel, and that's the respect we showed to them. And it is important that we do this, because our problem resolution should be done with dignity in the court system and outside as well. Thank you. I hope you liked the program. If you did, you can make your comment liked at the bottom of this video. Thank you.